Welcome back to our COVID Part 2 webinar. I hope that you and your families are safe and healthy during this unprecedented time. I'm Stephen Crine, President and CEO of the Canadian Employee Relocation Council, and I'll moderate the discussions today as we discuss the complex challenges of managing global mobility amidst the chaos of COVID-19. As I mentioned, this is part 2 in our 3-part series of webinars dealing with some of the issues surrounding COVID-19. And today we're taking a closer look at some of the tax, immigration, and employment law issues. As we noted last day, this is a very trying time for all of us, and most importantly for our families, our employees, and our mobile workforce. And the importance of an employer's duty of care has never been greater than it is at this time. There's no playbook for managing the myriad of changes that are coming at us daily. And our expert panel today will share their experience and give you some helpful tips that will help you navigate some of those challenges. Some housekeeping items just to keep us on track. We've allocated a little bit more time than what we normally have for webinars. We're keeping this open until 3:30 to provide an opportunity for the questions and answers. Speaking of which, you can ask questions. Sorry, we're just having a little, the mouse is going all over the place here. Back to the housekeeping. You can ask questions throughout the webinar using the chat feature on the right-hand side of your screen. We'll be gathering those up as we go through the session. So please make sure that you get your questions in, and we'll be gathering those up and posing them to our panelists. In the event that we don't get to all of the questions, we will issue a supplementary update following the session. We will send you the slides from today's session in a follow-up email following today. You'll also receive a recording of the webinar as well. So if you miss anything, you'll have the opportunity to return to it. For those enrolled in the CERC Professional Designation Program, there are 2 continuing education credits for your participation today. And as always, if you have suggestions for future webinars, we'd love to hear from you. Now I can go to the next slide, which is where we say thank you to our sponsor, Whitecoat Workforce Mobility, for their continued support in helping us to coordinate and provide the programs through our webinar program. So there's no doubt that the legal complexities involved in moving employees today are on the increase. And with the onset of the COVID virus, those complexities have multiplied. So it's vitally important that companies have the best programs and policies in place to manage their global mobility programs and ensure that they are compliant with the various aspects of regulations that govern workforce mobility. We have structured the event today in more of a Q&A style, so I encourage you to post your questions in the chat box on the right-hand side of your screen. We'll be taking a closer look at travel restrictions with an update from Stephen Green. We'll be looking at compliance considerations with Gabriella Rameau, tax considerations and compliance from Shivani Joshi, and employment law considerations with Stephen Tusha. So just before I introduce our panel in more detail, and thank you very much for being with us, each of you. I greatly appreciate your participation today. Just before we do get going, as I mentioned, the situation is changing rapidly with COVID, and Here at CERC, we're doing our very best to keep you updated. To that point, we've recently developed a COVID resources page on our website where here you can share your experiences, provide helpful tools and articles that you may have come across or may have prepared. And there are also very helpful links to government resources, public health, immigration, tax, etc., that are updated on a regular basis. So welcome to our panel this afternoon. And the way we are going to do this is each of the presenters will give a brief review of the main issues to be mindful of when managing your mobile workforce and temporary foreign workers. And then at the end of those presentations, we'll go through and take up the questions. And many of you have already shared questions with us in advance of today's call. Okay, so welcome to our panel members. And our first presenter this afternoon is Stephen Green. Stephen is one of the two senior partners at Green and Spiegel. He's a certified and is certified as a specialist in immigration law. He's been practicing law for over 30 years, although from his picture, he doesn't look that old. He has been a subject matter expert at many of CERC's events, and he's served on our board of directors, chaired our government relations committee, and so we're very pleased to have Stephen with us this afternoon. And then our next presenter is Gabriella Rameau. Gabriella is with Ernst Young Law here in Toronto. She's got over 27 years of experience practicing exclusively in the field of corporate immigration and citizenship law. She's served for many years as a member of the OBA's Citizenship and Immigration Section Executive in many capacities and is currently the chair of the section for 2019-2020. She's also spoken at many industry events and has presented at the CERC conference and webinars and regional events on a number of occasions. Our next presenter this afternoon, Laura, maybe you can run that for me because it's very slow for some reason. There we go. Thank you. Oops, one back, please. Thank you. Great, thank you. Pleased to introduce Shivani Joshi. She is a senior manager with Global Employer Services at Deloitte. She is a senior manager in the GES practice. She's got over 16 years of experience in international tax, cross-border payroll, and global employer services. Shivani also presented the CERC webinar for the tax year end last November, December. So very pleased to have you back with us this afternoon, Shivani. And then our final presenter this afternoon, who'll be talking about employment law, is Stephen Torsha. And Stephen, next slide, please, Laura. Thank you. There we go. Stephen Torsha joins us from Calgary this afternoon. He's a partner at Miller Thompson. He provides trusted advice to clients on a wide range of labor and employment issues, and his practice covers all aspects of employment relationship, from hiring to firing. He has a broad range of experience in many other areas of litigation, including health law, creditors' rights, professional negligence law. And one thing that's quite interesting about his background is that he worked for Citizenship and Immigration Canada as an immigration officer at ports of entry while he was studying at university. So I'm sure that you'll feel at home weighing into some of the discussions on immigration as well, Stephen. So, hey, so that's our panel today, and thank you very much for being with us. As I said, greatly appreciate your participation, and very much looking forward to the presentations this afternoon. I'm going to hand things over to Stephen Green. Stephen will then be followed by Gabriella and Shivani, and then we'll round it out with the employment law from Stephen. So, Mr. Green, if you are ready, we'd love to hear from you now.
Great, thank you very much, Steve. So good afternoon. What I'd like to do is to give everyone a general overview of how many people are involved in this so-called entry ban into Canada. And I think it's important to understand that immigration, IRCC, they make up the policy that is supposed to be implemented by the other division, which is CBSA, our border service officers, who try to interpret what IRCC has written, and then they implement it. We also have a Quarantine Act, which is involved in the entry of people. So there is a situation where, we've heard that people have to quarantine themselves for 14 days. We also have public health involved in determining, in some circumstances, who can come into Canada. So you see that we've got 4 departments that are responsible for determining who is eligible to come into Canada, but it really is, in my opinion, the CBSA officers, those border service officers that are at our airports and that are at our ports of entry where people are driving in from the United States. But a really interesting group that has also been involved in sort of the gatekeeper concept of this ban is the airlines. So if you are flying into Canada, you first must be able to satisfy an airline person who is checking you in that you meet the exemptions that permit you to come into Canada. Because it starts off with, the government has said there is a ban from coming into Canada. And then they give us a list of situations that you are not banned from coming into Canada. So really it's the airline that you have to satisfy if you're flying, and then the border service officer who will then examine whether or not you meet those special exemptions from the ban. And one really important takeaway that I'd like everyone to get from today's discussion is that it is extremely fluid. The interpretation of the policies by immigration and the other departments, by the airlines and by the border service offices, are constantly changing, unfortunately. It's getting a little more consistent, but still you must be aware that there is a tremendous amount of interpretation that is being applied at various ports, at various airlines, so you get different answers sometimes that don't make sense. So it's important to understand that some borders interpret things very differently than other borders, and it would be, proper for you to try to investigate, hey, if someone is coming into Canada, what are the borders that interpret it hopefully in a more liberal way than the ones that aren't. So now that we understand that you've got the airline to deal with, you've got the border people to deal with, how do you get into Canada with respect to the ban? And again, it's really broken down into 2 areas. People that are coming from the United States and people that are coming from everywhere else besides the United States. So a lot of questions we are asked is, I'm a Canadian citizen in Canada. I'm on a work permit in Canada. I am a student in Canada, and I've got an immediate family member who's in the United States now, and I want them to join me. And again, the government defines who can join: Canadian citizens that are in Canada, permanent residents that are in Canada, workers that are in Canada, and students in Canada. And it is, spouses, common law partners, same-sex partners. The definition of dependent children, that's children under the age of 22, parents, step-parents, and guardians are immediate family, and they can come to join someone who is in Canada. And they can drive up to the border, and at the border, they must be able to prove to that border service officer that their entry into Canada, and this is the words that they use, are not optional or discretionary. And that's a pretty big definition. But you must be able to establish that at the border. And you can't be in a situation, and the borders have, stated this, that you aren't, you're not coming to Canada to weather out the storm, the COVID storm. You are coming to Canada to stay here and be with your person that's on the work permit, or be with your Canadian spouse or permanent resident spouse. So that is the toughest thing to establish if you are coming from the United States. So if you're driving, you only have to satisfy the border service officer. If you are flying, some of the airlines have taken that on to say, hey, is your entry optional? Is it discretionary? So you have to be very careful and be in a position to establish that if you are coming from the United States. You must also have a quarantine plan available when you cross the border or arrive in Canada by flight. And again, that quarantine plan would be where you're going to stay for the 14 days. How are you getting your groceries for the 14 days? If you need pharmaceuticals, how are you doing all of that? And if you don't have a proper quarantine plan, then you can be denied entry, or they may let you in and then put you in a government quarantine situation. So you don't want to be in that difficult position. So make sure you know your quarantine plan, and make sure you have enough evidence to prove that your entry is not optional or discretionary. Obviously, you can't come for a holiday. That the summer months are coming. It's going to be quite difficult, in my opinion, for people that are in the United States, mostly Americans, that may have bought cottages and they want to come up and holiday during the summer time. So they're going to have to watch out for that. Now we look at the other group of people. These are everyone else who's in another country, not the United States. And again, the same rules apply if you're joining a Canadian citizen or permanent resident, you're joining someone that's on a work permit or a study permit, or you have your own current work permit, or you have your own current study permit, or you've been approved for a work permit. You are able to come into Canada. You would show the first gatekeeper, the airline, that you are coming into Canada. You've got a work permit, whatever you've got, your study permit, and they will say, no problem, you can come in. But anyone else that does not have a work permit, that is not on a study permit, that is not a Canadian citizen or permanent resident, but really is only on a visitor visa or from a country that is exempt from the need of a visitor visa, they're going to need a special authorization to come into Canada. And again, you would have to contact the High Commission, or there's a special email that you get this special letter that lets you board an airplane to come into Canada. But that still does not alleviate the problem of making sure you're not just visiting Canada for a holiday. And the difference here is, unlike in the if you're coming from the United States, where you must show that your entry is not optional or discretionary, this definition is that you must be coming to Canada for an essential purpose. And the government seems to have indicated that if you're coming as an immediate family member, that's an essential purpose. But again, if you indicate you're just coming to weather out the storm, that may not be an essential purpose. So just be aware of that you've got to be able to show that it's an essential purpose for you to come into Canada if you're coming from outside of the United States, and if you're coming by the United States, that it's not optional or discretionary. And in both situations, you must have a proper quarantine plan available. And the government now even makes you fill out a coronavirus form so that they can track you when you come into Canada, both at the port of entry and if you are flying. So those are my general comments. And Gabriella, you're next.
Hi. Thank you, Stephen. We just flip the slide. To my slide. So immigration compliance in the time of COVID, it's an interesting topic because, as many of you I'm sure are aware, for some time now, the Canadian government has had in place regulations that require employers maintain and meet all their commitments that they made to foreign workers when they brought them to Canada, in particular in relation to terms and conditions of employment. And so we find ourselves in unprecedented times, and beyond the health impact of COVID-19 are the economic implications. And while we undergo lockdowns that are preventing people from going to work and so many businesses being declared non-essential services, the economic impact of the pandemic has been quite severe, as I'm sure many of you are experiencing in your own workplaces. What that has meant for the companies and employers who employ temporary foreign workers is that as they look at the different levers that they have to address the pandemic and the economic impact of the pandemic, they also need to pay particular attention to their temporary foreign workers. So if you don't have any temporary foreign workers and you're looking at options such as reductions of hours of work, or you're looking at laying staff off, or you're looking at instituting pay cuts across the board in order to prevent layoffs. If your entire workforce is Canadian, then or permanent residents of Canada, you would look at the employment law implications of that, and I'll leave that for my colleague Stephen to review. But if you have temporary foreign workers, you also have to look at the immigration compliance impact of that. The Bar Association and a number of lawyers have approached the government on many instances with questions regarding compliance and what kind of position are the authorities going to take if you have temporary foreign workers and you cut back their wages, so you're no longer meeting those terms and conditions of the offer of employment that you gave them at the time that they came to Canada, that are now listed on the labor market impact assessment that you got in order to bring them, or if they were LMIA exempt, on the offer of employment that's in your portal. What's going to happen if you need to make those changes in order to address the economic impact of COVID-19? We've asked the question. The government is looking at it. There has been some indication that they're looking at perhaps in certain areas loosening up some of those restrictions, but they haven't made any commitments yet. And I actually just simply think that in the middle of this pandemic, feels like it's gone on forever, but we're really only in week 6 since things really started tightening up. And I think that there have just been other priorities, programming priorities, and relocating, repatriation of people who are outside of Canada, et cetera, that the government has been focused on. And I think the compliance piece is starting to come along now. So I suspect that we'll get further details in the next little bit of time. But at the moment, what do you do? And there are several issues where clients have been raising this question. And the first one, and the one that we have heard the most, is around location of employment. Your job offer would have said that the individual would be working at location X. But a lot of employers now have people working from home. And so the question is, if I have my employee working from home, am I breaching the conditions of my LMIA or my offer of employment in the portal? At this point, I think that you are safe with having individuals work from home under these conditions. You know, the basic purpose of the compliance regime is twofold. It's to protect the foreign worker from abuse, and it's to protect um, the labor market from abuse. I think having individuals working from home during a pandemic, particularly when that home is in the same geographic location as the office that they would normally work out of, I don't think is a change that they're likely to say was a breach of conditions. You're doing it for the protection of the foreign worker, not to their disadvantage, and there is really should be no impact on the labor market. Obviously, they need to be looked at individually to make sure that there are no impacts, but I think generally speaking, you're likely safe to have people working from home. The other terms and conditions of employment that come up, things like what if you want to reduce wages, reduce salary? What happens if those reductions are such that you go under prevailing wage? What happens if you want to reduce hours of work? And so now somebody on an LMIA is no longer doing full-time work. Or what happens if you have to lay people off? How does that impact your position as an employer vis-a-vis compliance? If we can just flip to the next slide, please. I think at this point, we need to exercise common sense. No, sorry, one slide too many. Just go to the one before that, please. So I think as an employer, you know, there is no certainty right now, but I think we can look at the things that the tools and levers that are available to us under the compliance regime and see how we can lever them to make the situation best as possible. Frankly, I understand that, you know, employers can't wait for IRCC and ESDC to come out with further information because they have to make these decisions now. That, you know, the situation is in the moment and we don't have a lot of time to think about it. What I've been advising my clients is if you're dealing with somebody who's on an LMIA-based work permit, what I have suggested is that you notify Service Canada by sending correspondence to the officer who approved the LMIA saying, look, as a result of COVID-19 and the economic impact on our business, we have had to, whatever it is, cut back hours, cut the salary, laid off people. By doing so, I suspect you will not get a response, particularly at this moment, but by doing so, you have at least put the notification in place. So on a future inspection, if this come up, you can at least have some proof that you try to advise the authorities. A little bit tougher on the IMP LMIA exempt side, because short of filing a voluntary disclosure, which essentially means that you're saying that you breach the compliance obligations, there's not a lot of way of notifying. The only thing you could do is put in a new offer in the portal with the new terms and conditions, with a new wage, and then get a new work permit, which you can't do because right now getting a work permit issued is nearly impossible, if not impossible. So your hands are tied a little bit more. So you're sort of going to have to rely on your explanations at the time you have an inspection, if it comes up on an inspection. The other programs that are affected by changes in terms and conditions of employment are also the ones under the provincial nominee programs, things like the OIMP and the provincial nominee program in BC. The issues there, and a lot of the provinces have their own compliance regimes, which you also have to be aware of. I can tell you that Ontario, for instance, is looking at how they're going to address the impact. So if you have somebody who's received their certificate, for instance, as a provincial nominee, or who has an application pending, and then there's a change in those terms and conditions that were listed in the nomination application, how is that going to impact the individual if they haven't gotten PR yet? These are issues that the government is looking at, but the consistent message across the nominee programs is notify. If you need to make these changes for economic reasons, then you go ahead, you make the changes, and you notify the program. And then you wait and see what they do with that information. I suspect most of the programs, this is an unprecedented time, and they're looking to be reasonable. So I think we're going to start seeing some policies around that in the next few weeks, which will, I think, be of some comfort to employees and employers, but we don't know for sure. At this point, all you can do is you do what you have to do from an economic perspective. You notify the authorities, and then wait and see until the policy comes out. Some things you can do to protect yourself, though, as an employer, as you're making these changes. Ensure wherever possible that the changes you're making are broad-based and do not only impact your foreign workers. So if you're instituting a pay cut, make sure that pay cut is across your workforce and not that you're just changing the wages of foreign workers. If you're reducing hours of work, again, make sure that those hours of work are reduced across your workforce fairly and that they're not disproportionately impacting your foreign workers. So you're not reducing your Canadian workforce by 5% of their hours and your foreign workers by 50%. You want to make sure that whatever you do, it's obvious that you're not targeting your foreign workers, but rather you are attempting to deal with an economic situation as equitably as possible. Because you may have to justify this or deal with this in a future inspection, make sure you're keeping good documentation. Make sure that you have documentation in place, for instance, pay slips of your foreign workers and your Canadians, so that you can show that that pay cut was applied equally to both. And the other thing to remember is that the immigration regulations do provide a series of justifications that allow you on an inspection to say, yes, there was a change in the terms and conditions of employment, but this was a justified change and therefore not a breach. And the justification that I think will be of most use to employers is the one we find at Section 203 1.1c, which reads, the implementation of measures by the employer in response to a dramatic change in economic conditions that directly affected the business of the employer, provided that the measures were not directed disproportionately at foreign nationals employed by the employer. So I think in the future inspection, if you have a foreign worker where you cut back the wages, and the officer comes back and says this was a change, I think, when I read this, it's definitely a dramatic change in economic conditions. I don't think we have seen a more dramatic change in economic conditions this quickly in my entire lifetime. The economic impact has been greater than the Great Depression. So if this justification wasn't designed to deal with the economic fallout of COVID-19, I'm not sure what it's designed to deal with. So can't guarantee you that they'll accept it, but I'm fairly confident. And perhaps because I started my life as a litigator, I always think to myself when I'm advising clients, could I go in front of a justice of the federal court and argue that what my client did is a reasonable thing? And I think relying on this justification during the time of COVID is eminently reasonable. If we can just go to the next slide, please. So some things that you need to know about additional compliance obligations. As Stephen just spoke about, individuals who arrive to Canada are required to self-isolate for 14 days. And on April 1st, the government sent a letter to employers who had foreign workers under the Temporary Foreign Worker Program, the one where you're getting an LMIA, which imposed some additional obligations. And the first one was you have to allow your foreign workers who arrive in Canada to self-isolate for 14 days, and you have to pay them their wages, a minimum of 30 hours per week. So if you've got somebody, say you're in the agricultural sector and you brought in some foreign workers as harvesters for your operation, they can't work for those 14 days, you have to pay them a minimum of 30 hours a week for those 2 weeks. If your conditions under the Temporary Foreign Worker Program require you to provide accommodations, again, those of you in the agricultural sector, that would apply to you. And there's other instances where you have to provide accommodations. You have to ensure that those accommodations allow the individual to meet their self-isolation requirements. You have to ensure that they're adequate space. So the beds are 6 feet apart, the dining room chairs are 6 feet apart, essentially. You need to ensure that you are separating those workers who are under self-isolation from those who are not. So you can take 4 people that arrive together and put them in self-isolation together, but you can't put 2 and then 2 workers who have been here for a couple of months that are no longer self-isolation. You have to ensure that you keep them away from any vulnerable people, so people over the age of 65 or who have compromised immune systems. And you have to make sure that you provide them with sanitation materials. And yesterday, or perhaps the day before, the government issued some further information on that in relation to inspections. Up to this point, we had been advised that most inspections have been suspended. They had not been doing, your normal inspections that you get, asking for pay slips for the last 3 months and things like that. But they are going to be implementing inspections under the Temporary Foreign Worker Program. They're going to be done remotely and virtually. When you are contacted, you will have 48 hours to respond. So it's really important that you have documentation in place. Employers will be asked to provide proof that they have paid the workers during their self-isolation period, so pay slips for those 2 weeks. And they will also be asked to provide photographs showing that you are meeting the requirements for the self-isolation. So the beds being 6 feet apart, the chairs being 6 feet apart, that there's adequate places where the foreign workers can wash their hands, that there's sufficient and appropriate materials to disinfect the living space on a regular basis. They can actually ask you to give them a virtual tour with your cell phone. You show them the living space. You have 48 hours to respond. If you fail to respond after 5 days, they will send out a notice of a finding of non-compliance. You then have 5 days to respond to that. And if you don't do so, then they will move to penalties. And the penalties are the same penalties under the Administrative Monetary Penalty Scheme. So you're looking at penalties ranging up to $1 million, depending on the violation, and you are looking at bans under the system as well. So you have to ensure that you are assisting your employees in their self-isolation plan. And I would argue, although I don't think it's a requirement in the same level that it is for those who you're providing accommodations for, but I think if you're bringing in workers under the Temporary Foreign Worker Program and they have no support base in Canada, if you're going to be able to get them past that CBSA officer, you're going to have to assist them with a self-isolation plan by providing things like ability to get online groceries or to have groceries delivered to them and where they're going to be housed for those first 14 days. So that's compliance in a brief nutshell.
That's great, Gabriela. Thank you. I'm sure there's going to be, I'll just remind folks that if you have questions, use the chat box on the side of the screen on the right-hand side, and we'll be taking those up through the session, and we'll be getting to those later on. So our next presenter, Shivani, welcome.
Thank you, Steve. As countries implement these travel restrictions, Gabriela, Stephen both spoke about that. Many cross-border workers are unable to physically perform their duties in their regular place of employment. And what brings this to the table is the questions of taxing rights of the countries in which they would normally be expected to work vis-a-vis they are working in the current situation of the pandemic. As we know, that tax obligations are an outcome of individual tax residency, which in turn is dependent on bright line tests in some countries, which are day thresholds, or it could be a fact and circumstances based, like in Canada. So if an employee during the crisis moves himself or his family to another location, which is not their usual place of employment, it could have an important bearing on how their tax residency changes, and which further results in a change in their own personal tax filing obligations and also impacts that of their employer's payroll obligations. While when we're looking at international borders, there is an international tax treaty network. But however, how these policies would apply in the current pandemic, it needs to be seen. OECD recently issued guidance on how countries can interpret the tax treaties in instances where employees are stranded abroad or are working remotely due to the crisis. This guidance does provide an analysis on how the tax authorities should interpret questions about corporate tax residency, permanent establishment issues, or where the cross-border employees are involved, how their income should be attributed. However, while many countries are proceeding to give their guidance, it is on each of their countries to whether agree or introduce clarifications depending on their own tax laws. This week in US, IRS announced that their guidance regarding the tax issues related to the travel disruptions arising from the COVID-19 emergency. The guidance provided that under certain circumstances, they would consider up to 60 consecutive calendar days of US presence to be arising from travel disruptions and accordingly be excluded from determining US tax residency, and also for looking at the treaty exemption available to that individual for performing personal services in the United States. Many countries took up the OECD guidance, followed suit. UK, Australia, last week Singapore have guidance, but till the time any country does not issue guidance, how would these thresholds impact the tax residency? Or even when they give these guidance, every country will tweak it according to their system. Some situations would be covered and some situations would not be covered. Tax situations, not right now, but as we see time progresses, would need to be discussed and evaluated as to how they have impacted the individual who is working at a different location or has an impact on the employer as to how their obligations towards the employee, towards their payroll remittances, towards the social security that gets applied has changed. And the guidance is clearly needed from the tax authorities because obviously the situation has not presented to us before, and the rules or the views that each country could take could all be different, they could align, and that depends on how the situation evolves. Then from a more granular perspective, the usual items we see that when the crisis came, many organizations released notices on how they're enabling their employees to work remotely. They were giving grants ranging from $100 to $1,000 for them to buy computer equipment. So when these benefits are being introduced into the picture, are they taxable or are they not taxable? Again, it depends. Generally, in normal situations, unless there are thresholds within the administrative positions, these items would be considered taxable. In Canada, CRA issued a view yesterday that they are willing to accept a reimbursement of up to 500 Canadian dollars for purchase of personal computer equipment to be principally for the benefit of employer. So indeed, a welcome clarification because it settles some of the issues surrounding whether or not all these payouts which were happening in Canada, would they be subject to tax? And if yes, after or what limit? Given this, and to the extent the tax authorities issue guidance, it will help employees manage their tax compliance. In the current context, deductibility of home office expenses is also some of the issues which are being raised. And while many provinces allowed only the essential businesses to remain open, many mandated the need for other businesses for the employees to work from home. Does this raise the question of employees being able to claim additional expenses? Is an employer required to issue T2200 in this situation? These are various aspects on which the various organizations are asking these questions, but what is eventually depends on whether or not CRA issues a view on what will happen in this situation. as we can see, many organizations, many countries are coming up with their own views on what the situation and how to classify it. And accordingly, tax authorities are coming up with extensions for tax returns, extensions for filing tax payments. But as we go deeper into the year, we would see that further guidance is needed to deal with the issues presented during this time. From an employer perspective, it is important to understand that has the change in employee's position resulted in any change in the employer's withholding and reporting obligations. Organizations should review wherever there is an impact on the expected work pattern of the employee, long-term assignees, short-term business travelers, your traveling directors, your non-resident board members. Wherever there is a change in the work pattern of these stakeholders, how would an organization's reporting obligations, withholding obligations for income tax change because of the impact the crisis has created? At the same time, businesses also need to look at, there are some hard decisions being made out there for layoffs. All have tax outcomes, and so it is important for employers to look at them as well. Some employers are also looking to review their compensation structures. Clearly, there is a huge economic impact of this crisis, and if it involves altering existing variable pay plans, existing equity incentives that have been granted out, all of these have a tax component, and it could be a substantial positive impact to the employee if tax matters are considered before going ahead with those changes from an employer perspective. As we move ahead, the organizations should now move from an immediate reaction of employee safety and business continuity to review the tax issues as we move ahead in the year and look at the next set of issues which are presented. To summarize the thoughts, as we move through the various phases, initially to responding to the situation, then we will gradually look at the recovery phase, where businesses need to make use of the various government measures that are being put forward. They also should look at any incentives to which they qualify, work with other stakeholders in the business to see if we can go ahead and get those benefits, which would help manage the cash flow for the organization, overall helps the business, and it helps the employees at an individual level make benefit of those measures that are being put out there by the governments that would really be fruitful at this time. And as we settle in, there is also a call out from mobility professionals to look at the year ahead, because they could now, this crisis has presented an opportunity to look at how the policies, the tax reimbursement policies, the assignment policies, how they should evolve and change to the upcoming scenario, because it's a new scenario that would present itself, and how best to align our mobility policies, keeping the tax considerations in mind to prepare the organization for the next steps. Over to you, Stephen. Thank you.
Thank you. So before we get to today's question and answer portion of the presentation, I just wanted to touch on a few topics that have come up a lot recently. I want to talk specifically about constructive dismissal and temporary layoffs, just to give everyone a bit of background information so that we're all on the same page. I'm of course speaking from the perspective of a labor and employment lawyer. I'm based out here in Alberta, so most of my experience is with Alberta law, and there are a few differences that Gabriella and a couple of my other colleagues have noted with respect to some additional limitations and restrictions that apply to some temporary foreign workers, and we'll note those as we go through. But you've probably read articles in the paper or heard interviews from lawyers who are saying that putting an employee on a temporary layoff is risky because it could lead to a constructive dismissal. And I know every time a new article like this goes out in the National Post, because we start getting a bunch of calls from worried clients. These articles are usually technically correct, but they miss a lot of the nuance and context. The leading case on what is a constructive dismissal in Canada comes from the Supreme Court in a case called Potter. There, the employee argued he was constructively dismissed after he was placed on a lengthy administrative leave while his work conducted an investigation into his conduct in the workplace. He sued, arguing that he was constructively dismissed, and his claims were denied until they got to the Supreme Court. At the Supreme Court, they took the opportunity to review the law of constructive dismissal and clarify what they called a two-part test to determine whether constructive dismissal has occurred. The first part of the test is looking at whether the employer's unilateral change was found to be a breach of the employment contract, and if so, does that breach does it substantially alter an essential term of the contract? So to unpack this for a second, if the change is permitted by the contract, then we don't have a constructive dismissal. So what the employer did was within its rights and its authority under the employment agreement with the employee. But if there is no clear authority in the contract to do that, you go on to step 2 in the analysis. Change has to substantially alter an essential term of the contract. So the change has to be to an essential term. If it's not an essential term, then there's no constructive dismissal. That begs the question, though, of course, what is an essential term? Those tend to be, in my view at least, the things that are really important to the employee. Things like pay rate, vacation, job titles, duties, those kinds of things. The rule of thumb that I like to use is that these are the kind of things that the employees are probably negotiating over when they're first hired, or if you're dealing with a promotion or a raise. Those are the things that tend to be really important to the employee. And now, even if the change is to a fundamental term, it has to be a substantial change. The classic example of this is when a salary component is changed with an employee. Obviously, that is an essential term, but if the change is minimal, 10% or less, then usually the courts don't look at this as a substantial change, and therefore there is no constructive dismissal. So then if a temporary layoff is authorized by an employment contract, and I guess we can go on to the next slide, please. If the temporary layoff is authorized by the employment contract, it's not a unilateral change, and it is not a constructive dismissal. Unfortunately, I think in my experience, at least, most employment agreements don't always contemplate a temporary layoff. But if you do happen to have an employee with a provision in their contract that allows for a temporary layoff, then you're not really at risk of a constructive dismissal in those cases. Another example of what is not a constructive dismissal, if an employee agrees to the change, then you don't have a unilateral change that's being imposed by the employer, and therefore it's not a constructive dismissal. We've seen this a lot recently, where an employee is much more likely to agree to a proposed change to its wages or her job duties if the alternative is to go on employment insurance and look for a new job. Now, some might question whether this agreement is truly voluntary in these circumstances, but that's another question for another day. The point being, if the employer and the employee do agree to some changes to the terms of employment, that's not a constructive dismissal. And finally, if the change is something that is not unilaterally imposed by the employer, it may not be a constructive dismissal. And some have been arguing that if your business is closed by order of the government, then this is not something that's being imposed by the employer, but it's being imposed by some outside force, and it should not be a constructive dismissal. This has been leading to some discussion amongst employment lawyers about whether this kind of situation would lead to a frustration of contract. I can tell you from having looked into this that the law is far from settled as far as it concerns frustration of contract in times of economic downturn and pandemics. So this is certainly an area that we're going to be watching, and I can guarantee that there'll be a lot of employers that may be making some arguments about frustration in defense of a constructive dismissal or even a wrongful dismissal action in the near future. Moving on to the next slide, I just want to touch briefly on a few other topics that are frequently asked by clients, especially in the last 6 weeks or so. Most provinces have a provision in their employment standards legislation that deals with temporary layoffs. The details differ from province to province, but generally a temporary layoff allows an employer to maintain an employment relationship with an employee without actually having to provide them any work. And during that time, the employer usually does not pay them. They're temporarily job attached. Usually at the end of the period, if the employees are not recalled, they're deemed to be terminated, and that will trigger your obligations to pay them termination pay, severance pay in some provinces, pay in lieu of notice, all that good stuff. So unless this temporary layoff is permitted by the employment agreement, and we talked about that earlier, there is a risk of constructive dismissal. You're pretty clearly running amok of the test that we talked about earlier, but many employers, in our view, have been taking their chances because of the unique circumstances that we find ourselves in with respect to the COVID-19 pandemic. If you constructively dismiss an employee by temporarily laying them off, you're not really in any worse situation as far as damages go than if you had just dismissed them at the outset. If you go with the temporary layoff route, however, you're at least potentially buying yourself some time to see if the economic circumstances change, if the government restrictions are relaxed, and you're able to bring back the workers into the workplace. If that happens, then of course, or if the government wage subsidies become available, perhaps you can start to look to bring employees back and things like that. But it essentially buys you some time, and it has, at least in these circumstances, less risk than it has in the past. With respect to emergency COVID leaves, most provinces now have implemented either brand new leaves or they're sort of adopting and using pre-existing statutory leaves for employees who are unable to work because of COVID-19. Usually these apply when an employee has to self-isolate or is unable to come into work because they are caring for someone who is self-isolating. Some provinces, the language indicates that an employer is able to require an employee to go on one of these leaves. Others, such as in Alberta, say that an employee is entitled to one of these leaves. But the general idea behind these leaves is fairly similar across the country. Recently in Alberta, the government introduced a new leave that applies to workers who have to stay home because of school or daycare closures. These are all typically unpaid job leaves across the country, but the details of the length of the leaves and the requirements to obtain leave vary from province to province, as do the requirements for the kind of documentation that the employee needs to provide in order to obtain those leaves. Looking forward, as we hopefully start to get back to normal, there's a few areas that we think that employers need to be mindful of. One of those is in recalling employees properly from a temporary layoff. Even if you think that the employee has moved on and found other work or new employment, we think it's still important that you should issue the recall notice, because this shows that you've fulfilled your statutory obligations under the relevant employment legislation in your province, and that you were prepared to rehire the employee or at least bring them back into the workplace. And this can help limit the company's damages if there is a constructive dismissal claim. It will give you the ability to argue that, well, up until at least the point of the recall, or from the point of the recall afterwards, the employee could have accepted that recall and mitigated their damages, and therefore the amount that the employee could potentially seek in court is going to be limited to up to that date that the constructive dismissal recall notice, the temporary layoff recall notice was sent out. Another thing to take a look at is re-examining your employment agreements to ensure that you have the necessary flexibility to deal with changes in the future. So, we talked before about whether an employment contract permits the kind of change that's being contemplated by the employer, and if so, then that wouldn't be a constructive dismissal. So I think it makes sense to take an opportunity like this to put in terms that would allow reasonable changes to duties and reporting functions and things like that, so that if there are situations that arise in the future, you're able to respond to them by implementing changes that are already permitted by the employment contract and avoiding the possibility of a constructive dismissal. And I think this includes maybe looking at including provisions that would allow a temporary layoff. And while you're looking at the employment contracts, take a look at employment policies as well. We should make sure that everyone is up to date and trained with respect to occupational health and safety and the right to refuse dangerous work. Travel policies and work from home policies have obviously become forefront in a lot of workplaces, and so this is a good opportunity to make sure that those policies are up to date, given the kind of experiences that we've now had dealing with this pandemic. Now, that essentially concludes my remarks with respect to employment law generally, and I think we're ready now to move on to the Q&A portion.
Great. Thank you very much, all of you. Greatly appreciate. There was a lot of information shared there, and I think that just to end on the on your last comment, Stephen, about using this as an opportunity. I'm sure that we will have learned an awful lot over the 6 weeks in each of the areas that you have each spoken about this afternoon. So as we look to the next part of this series, we'll be looking at some of the things that employers should be considering as the return to work protocols are being lifted. Before we get into the questions from the audience, just give you folks an opportunity to comment on any of the presentations that were made. If there are things that you'd like to just follow up on quickly, so that we don't lose those thoughts. Any comments?
Yeah, hi, Stephen. Thought that came to mind from listening to Stephen's presentation about looking at employment policies. Probably a good time to also look at your immigration policies and the way you structure applications, because one of the things you can do, for instance, is when you file your application for a work permit or for an LMIA and you're doing your contracting with your employee, is putting in, if you're putting into the employment language that says, you reserve your right to engage in layoffs in the event of we're never going to see a pandemic, but changes in circumstances, etc. You can also do that in your LMIA application and your offer in the portal. You can always say that, subject to certain conditions. So things you might want to start as we come out of this, lessons learned, things you might want to look at from the immigration perspective, as well as tightening up those policies and trying to foresee some changes in the future that you may want to kind of hedge your bets on moving forward.
That's great. That's great advice. Yeah. Any other thoughts? Okay. Shivani, question came in with regards to the guidance under the treaty. Has Canada issued any notices in that regard?
Thank you, Steve. As of the information available today, no. IRS only issued the guidance for US 2-3 days back, and I'm seeing every week some country is coming up with guidance agreeing with the principles that the OECD laid out, but we are yet to see a similar guidance from CRA coming up.
Okay, we'll certainly get that. We'll certainly get that link from you, Shivani, and get that posted on our resources page so that people can follow that as well. So that's great information this afternoon. Thank you so much. Question just came in. If I'm not sure who can best pitch this. I think maybe Stephen. If you don't mind, I'll call you Stephen G and Stephen T. Just for the purposes of today. So Stephen T, I think if you reduce hours of work for an employee due to business economic reasons, pardon me, just let me go back to the question. If you reduce hours of work for an employee due to business economic reasons, not the quarantine, can the employee apply for EI for the rest of the hours?
Okay, that's an interesting question, and I think it's going to depend on how significantly the hours of work and the wages are reduced. or things like the Canadian Emergency Response Benefit. I like to call it CURB because it gives me an opportunity to make a bunch of Curb Your Enthusiasm puns. But
Okay.
they have recently changed some of the requirements, allowing employees to earn a certain amount of money before they are disqualified from those benefits. So for a period of time, if you made any money at all, even if your wages drop by 95%, if you made any money at all, you would be disqualified from obtaining the benefits under CERB or CURB, sorry. So I think the answer to the question is that it depends on the nature of how much your wages have been reduced. And my understanding is that the government is funneling most of the applications right now for any kind of relief from lost wages through the CURB first before folks resort to employment insurance. So if it was business reasons that your wages were reduced rather than as a result of quarantine, I think the reason that the business had to reduce the hours was probably some way related to the COVID-19 pandemic in one way or another. You could probably make an argument that that it would therefore it would be allowed to apply under the CURB. That being said, the government has been encouraging everyone to apply for CURB, and they'll sort of sort it out later on. So there's always the opportunity to make your application for those benefits, and then pending further guidance from the government or further changes to the programs, I think we might see people having to do some readjustments to the benefits that they've received previously, and whether they need to pay any of those back, or whether there may be even further benefits that they could make themselves or could avail themselves of.
Right. Another question. Thank you, Stephen. Another question was in regards to the CRA view on the $500 support. We'll send that out when we send out the recording and the slides. We'll include that link for you so that you can get you can get the most current information with regards to the allowance. Yeah, we'll try to include as many links and different things that come up through the discussions this afternoon in the supplementary information that we send to you. There were a few questions. There were a number of questions that came in prior to the event, and we've got lots coming in on the screen. So we're going to jump around a little bit between them. And I think that I think we've answered this one, but I'm going to just confirm that with Gabriella and maybe Stephen Green. Are private and public corporations providing a financial support, a financial supplement? There wasn't an allowance in the original relocation policy for international relocating employees who are needing to quarantine for the 14 days upon arrival. And I think, Gabriella, you really covered that off in your presentation, but just to make sure.
Yeah, we've been getting some of these questions as well. I think you're likely okay. Again, a lot of these things turn on the facts, so it depends on, how large an allowance are we talking about. But if you are offering an allowance so that they can set up a home office, or you're offering an allowance for, they have to be in quarantine for the first 14 days and can't go stay at the home that they intended to stay in because there's a vulnerable person, for instance, and you want to provide an allowance so they can stay in a temporary accommodation or have their groceries delivered. As long as they're reasonable amounts, and in a future, again, this would only come up in a future inspection if you were asked to show what you provided to the individual. Obviously, you don't need to worry about disadvantaging the individual because it's actually an advantage. And if you're not looking at an LMIA, there's certainly no labor market impact assessment to be done on that. If it's somebody in an LMIA, normally what you would worry about with an extra allowance is, had you advertised that to a Canadian, would they have applied for the job? But I think that if this is an allowance because you're meeting the needs of employees that were unanticipated and that have arisen as a result of COVID-19, again, I would be making I would be comfortable making the argument that that is a justifiable change.
Mm-hmm. Mm-hmm. I guess there's going to be a lot of elements of common sense in some of these decisions and policies going forward?
I think at the end of the day, and again, that's why I said it depends on the facts, right?
Yeah.
So like if that allowance is $40,000, and I think you're going to have a different conversation than if it's like $1,000. So they could buy a computer monitor, a desk chair, and maybe pay for, for grocery delivery.
Yeah. Any tax issues related to that, Shivani?
Right, Steve, exactly. So in absence of clarification to that effect, and if CRA issues and consider this an exceptional period, exceptional payments, unless that happens, any benefit derived by virtue of employment would become a taxable income. So employers would need to look at whether or not, if they do, the first view is that it should be taxable, and if it's taxable, do they want to gross up that benefit by taking over the tax on that payment and paying it for the employees? So these are the issues from an employer perspective they need to be careful of.
Yeah. Okay. That's a great question. So thank you very much. Stephen Green, any comments on that, or should we? I think we've got that one nailed.
I think you have it nailed. Yep.
Yep. Okay. Then I'm going to maybe ask you this one that was sent in to us. Some organizations have suspended processing of work visas with their immigration vendors, partners. They are concerned about the uncertainty of visas being issued when travel bans will be lifted. Employees are currently working remotely, so why not continue to do so instead of proceeding with an assignment? Is this a good idea, and what are the implications? Any thoughts on that, Stephen?
Well, if they're working remotely from outside of Canada, there's no issue because you're not entering the labor force. Certainly, if they're inside of Canada, working remotely, then you are affecting the labor market, and they would need a work permit. So it depends where they are.
Okay. Thank you. Any thoughts on that, Gabriella?
Sorry, couldn't go off mute. Yeah, no, I would agree with Stephen on that, although I think, and I'm not a tax specialist, but I think there may actually be some tax implications to having people work long term, particularly if they're working for a Canadian employer outside of Canada, but I would defer that to my tax colleague.
Okay.
Right, exactly. In absence of a clarification from CRA or the country in which they are working to that effect, this could possibly have an impact on the Canadian employer from resulting in taxable presence in the country where this employee is working, unless we see guidance where that government, for example, US is saying that they'll exclude 60 days, but anything beyond that, would that raise questions? So the tax issues would become relevant in this situation.
So there's a lot of moving parts to this. Okay, let's move on. Next question, and this is regarding temporary foreign workers. So Gabriella and Stephen, I've heard some employers are ending assignments in favor of reassigning work to Canadian citizens or permanent residents. They may or may not continue to pay their temporary foreign workers, waiting for the earliest opportunity to return the assignee to their home country. I'm interested in understanding what are the implications of this approach, especially with regard to immigration and employment legislation. So Stephen Torsha as well, sorry, that question brings in some elements of employment law as well. Stephen Green, would you like to take a stab at that one?
Well, I mean, if the person came in on an LMIA and they're on a temporary layoff, then again, as Gabriella has indicated, you would want to notify Service Canada that is the situation. If they came in on a intercompany transfer or LMIA exempt type of work permit, again, it would depend on the circumstances. If they have been laid off temporarily, if your intention is not to bring them back, then again, you just must notify I would suggest immigration that you have not done a temporary layoff, but actual permanent layoff. And, that's what you would have to do. And again, you want to make sure of that from a compliance standpoint. Gabriella, do you have anything more to add to that?
Well, that's one of those where you're sort of eating your cake and having it too from the immigration perspective. Because there's sort of two sides to it. On the one side, and talking about someone who's an LMIA in particular, on the one side, what we're being told, if you look at that justification that I raised earlier, is that you're okay to make changes as long as you don't, negatively impact the foreign workers more than you do your workforce. But on the other hand, when you bring in a foreign worker to Canada, what you are saying is, I need foreign workers because there are no Canadians. And the whole premise of the labor market impact assessment process is to protect jobs of Canadians. So I would think that it would be difficult for an immigration or an integrity officer on an inspection to say to an employer, you laid off a foreign worker, we're going to penalize you because you were protecting Canadian jobs. Like, I just think it's one of those where, again, common sense has to prevail a bit. And as an employer, you're sort of between a rock and a hard place. And
a rock and a hard place, yeah.
But I think as an employer, if you can articulate that argument that, look, as a result of COVID, our work was down 50% and we had half of our workers were foreign workers and we wanted to protect the Canadians, I would take on that litigation if they were found to be non-compliant, because I think that would be a very interesting one to do. So, also the one thing you do have to be conscious if you are in that situation where you're bringing in low-wage workers under an LMIA and you're responsible for providing them with housing, and in particular you're responsible for repatriation, I think there are some concerns with laying them off if you can't repatriate them because of travel restrictions and then taking them off payroll. I think if you're going to put yourself in the position where you're laying them off, leaving them without a livelihood, no way to support themselves, and you have an obligation under your commitments to repatriate, and you're not repatriating them, leaving them without an income for that period of time, I think you have some risk there.
Right, and I agree that you have to look at, is it a high skill or low skill? And I think there's a higher obligation on an employer when they're dealing with low skilled workers, and the government's made that pretty clear by talking about repatriation, housing, all of that. So you really have to look at a low skilled situation a lot more carefully than a higher skilled one.
Thanks, Stephen. Please.
Go ahead. From an employment lawyer's perspective, what's being contemplated here, it gives me pause for concern that there might be some human rights issues involved as well. Anytime that you are treating your workers differently based on one of the protected grounds in the human rights legislation, like race or country of origin or other categories like that, I think that it calls into question whether there's a human rights implication here. The reason for the differential treatment, like laying off the temporary foreign workers in preference to the local Canadian workers, that's the protected ground doesn't need to be the reason that the action was taken in order for there to be liability. It just needs to be a factor. So we would have to point to some other reason why these actions were being taken to properly defend against a human rights complaint in this kind of a situation, and show that there was a bona fide occupational requirement, some other justification for why these steps were taken that had nothing to do with the protected ground in question here. So there was some discussion about the idea that the LMIA system is designed to protect the Canadian workers, and we'd want to take on an argument that that's exactly what we are doing by taking these steps, and that might go hand in hand with the argument that there's a bona fide occupational requirement here that would defend the same kind of argument that would be raised if there was a human rights complaint as well. So just something to keep in mind anytime you're making a decision to terminate all of your temporary foreign workers in favor of someone from a different place or nationality, right?
Yeah, it's one of the many places where sort of employment law and immigration law don't merge that neatly because they're and employers are put in positions where they're you know, where no matter which way they turn, they're facing risk.
Right. Well, yeah, and there's a supplement to that question where organizations have they've lost business as a consequence, and now they've got too many workers. Their workforce necessitated there weren't enough skilled workers to do the work in Canada. They brought in temporary foreign workers, and now that work's dried up, and they're laying off temporary foreign workers in favor of protecting Canadian jobs. So they really are stuck between a rock and a hard place. Okay.
I think we're going to see a fair amount of that. I think just based on just because of the nature of this particular crisis.
Yeah. Employees. I'm going to try and get through as many of these as we can. Employees with work permits are they allowed to exit and re-enter the country? What are the implications around that?
So if you have a valid work permit, you are allowed to exit the country if you can, but when you're re-entering Canada, subject to some of the public health exemptions like truck drivers and healthcare workers, you are then subject to the quarantine again for 14 days. And you should know that the government follows up on the 14 days. They will send you an email after saying, hi, you have now met the 14 days. You're permitted to get yourself out of quarantine. So
right.
It definitely applies there.
And the employer is responsible for the 14-day for the wages during that period of time. I think we clarified that.
Yeah. But then coming back into Canada, you must be able, again, it's considered a new entry. So if you're coming from the United States, you have to show that it's not discretionary or optional. And then if you're coming from outside of the United States, the essential purposes. And you're going to be asked by the Border Services officer, please prove to us, one, that it is an essential service, that the business is still operating, and that you still do have a job, because they will not let you in if you have lost your job, because therefore it's no longer essential for you to be inside of Canada. So you better be clear that if you leave, you have to satisfy that border service officer. If you're flying, you have to satisfy the airline, all of that. So it's pretty dangerous, in our opinion, to leave the country. If you're here, stay put.
Yeah, particularly during this period of time. Can my temporary foreign workers qualify for any of the emergency wage supplements like the CERB? And if so, does it impact their immigration PR application? Thoughts?
The only clarification we've received on this from the immigration side was during a call between the CBA and the government, not this week, but the week before, where they confirmed that if an individual is sponsoring someone to Canada and goes on on CERB, that won't count against them. So it's not as if you've gone on social assistance, so it won't count against you that way. But I have not yet been able to get a clarification from our tax colleagues and our global mobility colleagues in terms of the ability to qualify for the benefit itself.
And again, also, as a person obtaining permanent resident status, subject to a sponsorship of a family member, you have to be in a position to show that you have enough money to support yourself. And again, I don't think anyone's made a decision yet. Everyone's kind of, I wouldn't be too concerned about it right now if you've applied, through express entry or things like that, because they're looking at, do you have enough money in your bank to support you during that period of time? Sometimes they only looked at the job offer, but now you have to demonstrate that you have enough finances in your account. So again, each case is sort of different, and we'd have to look at it.
Okay. Okay. Can you explain the difference between closed and open work permits for temporary foreign workers? And is it possible, you know, I've got an employee, they're on a closed work permit, we've completed that work, how do I handle that?
Well,
Can
I mean, the simplest way to describe it is that a closed work permit is for a specific employer. You are given specific duties. Everything is very, very specific to that employer. And if you don't follow those, you know, specific things, the employer can be in, you know, violation, as Gabrielle has talked about, and the employee can also be in violation. Open work permit is what it states. I'm open to do whatever I need to do, with a few very limited restrictions on that. You know, in the healthcare area, you may have to have a medical before you can enter that area. So it permits you to do what you want, and they're two very different, you know, criteria to get.
Yeah, and I mean, there's limited circumstances for open permits. You know, the one that we see occasionally is I may have someone who's on a closed work permit for an employer, but they've applied for permanent residence, and they've, you know, been picked out of the pool. They've submitted their application. When they get to within 4 months of the expiry of their current work permit that's closed and names their employer, they can now apply for something called an open bridging work permit. And that's an open permit that they can work. But as a way to, you know, facilitate someone who's lost their job because of COVID-19, there's very few opportunities to move into an open permit.
Okay, thanks for the clarification on that. We're going to wrap up with two last questions, so we'll try and be very quick on these. This just came in. Any thoughts on future LMIA applications and how temporary layoffs will be considered? Our circumstances, many of our layoffs are temporary, 90 days or less.
Well, again, remember what an LMIA is. It's a labor market impact assessment. So the employer must demonstrate that they've checked the labor market. Are people available? So if you've temporarily laid off people and you can demonstrate that they are coming back, then you may be able to get that LMIA. If it is a totally different job, as opposed to the layoffs, you would have to demonstrate that. So it really is, you know, the particular fact situation, but at all times you must be able to demonstrate that you've tested the labor market and that at the time you are applying for this LMIA, there is no one available with that particular skill set in the labor market.
Okay, and thank you.
I think that the big question is going to be the long-term economic impact of COVID-19. And, you know, if everything were to go back to normal and, you know, people were back and then we still have the same labor shortages, yes, but I do think officers are going to be looking at LMIAs very closely.
More closely, yeah.
Situation where we're still sitting at, you know, what I don't know, the last figure, I think it was 9% unemployment, right? So
that's what they were saying, yeah.
Yeah.
Yep.
So I think if that unemployment rate stays high, I think it's going to, unless you're talking about highly specialized occupations where we don't have the skill set.
Right. Well, let's hope that unemployment rate comes crashing down very soon. Very last question, and it needs a little bit of unpacking, but you're very good at that. So there's a couple of different areas to this, including, I think, tax, the employment responsibilities, and of course, the immigration components. So here's the question. A number of assignees were on vacation or home leaves when their home country implemented travel bans, so not an unusual situation. They continue to have responsibilities for rental, accommodations, utility payments, the list goes on. They've got belongings here in Canada. So a company is asking, is it possible to end their assignments in Canada? That's the first part of the question. Second part is, how do we handle their personal responsibilities? I guess that means their utility and commitments, etc. And then the third point is, can they work from their home country? So thoughts in terms of what your advice might be to this particular company
Well,
what should they be aware of and doing?
from the travel ban, if that job does not exist anymore in Canada, then they would not be permitted, despite the fact they have a work permit, to enter, because the border officer would be of the opinion that it's not essential for you to be in Canada. You have no job to come to. So I think in that particular, at least on the immigration side, not commenting on anything else, but on the immigration side, I don't think you would be able to enter Canada, because what are you doing once you come here? Visiting? The answer would be yes. And there's a ban on visitors. So I think that person's in a very difficult position if there is no job for them in Canada for them to return to on their work permit.
And then from the perspective of if they want to work online from their jurisdiction, so that I guess I would assume the assignment continues, but they're working remotely. Again, because they're not physically in Canada, there's no limitations on that, other than tax consequences we talked about earlier. The one thing they would have to be careful of as an employer under the employer compliance is what terms and conditions were originally set out in their contract and in what they uploaded to their employer portal vis-a-vis repatriation. So if there was any repatriation costs they were supposed to cover, because you're leaving the, if you terminate the employee in those circumstances when they have responsibilities here and stuff, you'd have to make sure that there's nothing in there, any payouts that you would have to do because you had promised them in the contract, because that could become a compliance. Compliance continues even after the individual left, right? It continues for 6 years. So they, if they ever had an inspection, they would need to be able to show that they met whatever conditions were set in that offer that they uploaded to the portal, or that they indicated on the LMIA application. I think there may be some employment issues here, though.
Yes. Stephen Torsha, would you like to have the last word on that?
Yeah, well, I'll try to. So if there was a ban on travel that would prevent the worker from coming into Canada, and it was essential for the employer to, for the employee to be in Canada in order to do their work, I think that sets up an argument that there could be a frustration of employment situation here. Through some intervening factor that's of no fault of the employer or the employee, the contract of employment has become impossible to complete. And so that's sort of, it looks like the classic definition of a frustration of contract sort of situation, which would, give the employer and the employee the ability to decide that the relationship has come to an end, and according to employment law, there would be no further obligations owed by either party to one another. Of course, the added wrinkle of the immigration aspect of things sort of changes that a little bit, and I don't profess to have any kind of expertise in that area. So I would defer to my immigration colleagues about any kind of employment or any kind of further obligations that would arise in the immigration context after frustration. But if the employee or the worker was able to continue doing their work remotely without coming into Canada, then I think that may throw a bunch of cold water on the frustration of employment sort of argument, because the employer could potentially allow the employee to continue working and fulfilling their duties and obligations by doing so remotely. There's still sort of a whole line of cases that have arisen over time in the frustration of employment circumstance, where it's still possible to remain employed and provide services to the employer, but the way that it's done is so radically different than what was first agreed upon that there still could be a finding of frustration of employment. Maybe there's an argument to be made there, but again, I think it would be a little bit more difficult to make than if the employee was simply unable to do their job at all because they couldn't come into the country. So it's, as it's been said before, the circumstances really make a difference, and a lot of things will turn on the particular facts in any of these different circumstances. So your results may vary depending on the facts in your own case.
Well, we'll have to leave it. We'll have to leave it there for today. I do want to thank our panel for your time and taking these questions, taking the time to prepare for today. Greatly appreciated. I also want to thank all of the folks out there for attending. I hope you found the presentation of value in developing a more detailed understanding about the complexities in immigration, tax, and employment law. We will be sending out additional information and some of the links to some of the links to some of the issues that Shivani raised with us today, and any other things that we see coming across. We'll be updating our COVID resources page on our website. If you want to follow us on Twitter or LinkedIn, there's the addresses for those. If you have further questions at all, please don't hesitate to drop us a line at info@cerc.ca, and we'll do our very best to get you an answer to some of those questions as we can. I'd like to say thanks again to our sponsor, Weichert Relocation, Workforce Mobility, pardon me, for making the event possible. And a big shout out for Laura there in the background, helping us move things together. So I wish you all a very good day. Stay safe. The lawyers made me put this in the last slide. So I wish you all a very good day. Please stay safe, and I look forward to speaking with you again on May the 7th, when we'll present part 3 and hopefully the final part of the COVID webinar series. So I wish everybody a great day. Thank you very much for being with us. And once again, thanks to the panel. All the best. Take care. Bye-bye.
Thank you for inviting us.